Just when you think U.S. Court of Appeals Judge Harvey Wilkinson cannot be worse for the Second Amendment, he turns to himself and says, "Harvey, hold my beer from me." That's right. You're not going to believe what Judge Wilkinson did today involving the Second Amendment, specifically finding that short barrel rifles and suppressors are not protected arms under the Second Amendment. In fact, they're not even arms, apparently, according to Judge Wilkinson there in the Fourth Circuit out of Virginia and Maryland, dealing with the NFA. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a nominee for a 2025 Gundy's Award in the Top Voices of the 2A category. Voting will continue, I'm told, until this December 17th. So just a few more days to go to vote. If you're going to vote for the Gundys, link to the link to the Gundys is in the description of this video. Make sure you vote for Four Boxes Diner in the Top Voices of the 2A. All right, folks, so we have a decision out of the U.S. Court of Appeals for the Fourth Circuit down there in Virginia and Maryland. Case of United States versus Salim, which deals with the constitutionality of really the National Firearms Act. Specifically, the fact that it requires the registration of short barrel rifles and the registration of silencers, which are really just suppressors. Mr. Salim was convicted by pleading guilty to possessing an unregistered short barrel rifle and possessing an unregistered suppressor in violation of the National Firearms Act. He preserved his right to argue on appeal that this violated his Second Amendment rights. He argued that first to the trial court, it failed, and then he argued it on appeal to the U.S. Court of Appeals for the Fourth Circuit. He got a 3-judge panel, which included Judge Harvey Wilkinson, who, as you know, is the worst judge, one of the worst judges in America for the Second Amendment. And he wrote on a 3-judge panel that, of course, short barrel rifles and, of course, silencers are not protected by the Second Amendment. And what's interesting, though, is they really just mailed it in, just following their own precedent, right? They just cited to themselves in this 3-judge panel because this decision of the United States versus Salim is what is known as unpublished. Hear what I just said? Unpublished. So if you're not familiar with what that is, when courts of appeals make decisions, they can either publish their decisions, which makes it what's known as precedential, or they can decide to not publish it, which makes it not precedential. Now, remember, I've always talked about how the fact that every case is important. There is no such thing as a case that's not important. There are cases, however, that are not precedential. So, for example, this case was very important to our bad Salim, the defendant in this case. Very important to him because he's in prison, presumably. But it's not precedential, at least according to the views of Judge Wilkinson and the other panelist members. So therefore, they issued this opinion, but they made it unpublished and not precedential, presumably because they just said we're applying our existing law to these facts. No big deal, not a big case. We're just going to issue this 4.5-page decision and be done with it. I'll put a link to this decision down below, by the way. Nevertheless, there's a series of clear mistakes here and misanalysis that I want to make sure that you don't do the same things that the 3-judge panel did, including Judge Wilkinson, which, of course, we would expect him to make mistakes, whether on purpose or not, because he hates guns, hates the Second Amendment, and thinks that government should lord over us, apparently. So let's begin with the most basic misunderstanding of the Second Amendment here. In the opinion, they specifically write, this panel, that in determining whether the Second Amendment, listen carefully, in determining whether or not the Second Amendment's plain text covers conduct, we ask whether the weapon regulated by the challenged regulation were in common use for lawful purposes. Hear what I just said? Hear the problem? As you know, under Heller and Bruin, you start with the text of the Second Amendment as defined by the Supreme Court in Heller and Bruin. An arm is anything that can be used offensively or defensively, including something that can be worn, such as body armor. Text. To the extent the text is implicated by the conduct of the plaintiff or the defendant or the law, whatever it is, the burden shifts to the government. And what does the burden shift to the government to do? What does the government have to do? The government has to look at historical laws, historical legal traditions. You hear what I just said? They have to look at history. In Heller, that's exactly what the Supreme Court did. And in Heller, when they looked at the historical legal tradition, they concluded that the only conceivable basis for banning a firearm in America, or banning an arm in America, is if it were dangerous and unusual. And by extension, if an arm is in common use by Americans for lawful purposes, it cannot, by definition, be dangerous and unusual, because it can't be unusual. But here's the key part to understand, which the Fourth Circuit clearly doesn't get yet. The in common use test, whether or not an arm is in common use or not, occurs where in the Heller-Bruin analysis? It doesn't occur at the textual level. It occurs at the historical level. And why is that so important? If you're following the Supreme Court precedent correctly, and you can actually read cases correctly and honestly. Because it's occurring at the historical level, the burden is on whom? The burden is on the government to show that something is not in common use, because the in common use test arises from a historical tradition. And the only way you even talk about historical tradition in a Second Amendment analysis is when the text has already been satisfied. And yet here you have this Fourth Circuit panel literally writing, quote, whether the Second Amendment's plain text covers conduct turns on whether the weapons regulated by the challenged regulation were in common use for lawful purposes. They're conflating two distinct things that are supposed to be handled separately. The textual analysis first. If the textual analysis is satisfied, the burden shifts to the government to do the historical analysis. And yet the historical analysis dealing with the in common use test is at the historical level, not the textual level. And here you have the Fourth Circuit Court of Appeals with Judge Wilkinson blending the two, taking the in common use test, elevating it to the textual level, which I've explained to you, which is what every anti-gun person in America wants. Why? Because the burden has not yet shifted to the government if you're dealing with the textual analysis. It only shifts to the government at the historical level, but the in common use test is undeniably part of the historical analysis, because it derives from the history of banning dangerous and unusual weapons. By the way, if I said short barrel rifle, I'm wrong. I meant to say short barrel shotgun. It's a short barrel shotgun in this case, but the same concept either way. Now, what's weird is that this panel reaffirmed that Heller was reaffirmed by Bruin. Specifically, this panel wrote, nothing in Bruin abrogated Heller's extensive discussion of the contours of the scope of the right enshrined by the Second Amendment, which means they understand that Bruin just reaffirms Heller, and Heller is the arms ban case analysis, and in common use is part of the historical analysis. But this court simply skips over that and finds that short barrel shotguns can be banned. And of course, they cite to United States versus Miller, but here's the key. If you read United States versus Miller, it's not that long. By the way, United States versus Miller is generally very favorable to the Second Amendment, but we can do a separate video on that. But the bottom line is this. If you read what the United States Supreme Court said in the Miller case in the 1930s, it said that the reason why short barrel rifles or short barrel shotguns are not protected under the Second Amendment, they weren't saying it generally. They were saying it specifically in that case. And why is that? What the court said, and you got to be very clear about this, in Miller, is that the short barrel shotgun that Mr. Miller was convicted for possessing, there was no evidence proffered by Mr. Miller that short barrel shotguns were in common use, were typically used, were irrelevant to the militia or anything. And then the court went on to say, we are not able to take judicial notice of that question, meaning that it's up to Mr. Miller and his lawyer in the lower court to establish that this type of arm is protected, and they hadn't tried to even do that yet. And then it went back down and below, and I forgot if Mr. Miller then died or took a plea deal. I can't remember. One of them died. One of the defendants in that case died. The other one, took a sweetheart plea deal, and that was the end of United States versus Miller. But we don't have to get into that for the purposes here. The bottom line is that here you have this three-judge panel is saying that as a matter of law, short barrel rifles and short barrel shotguns are not protected by the Second Amendment. No one's done the analysis. And they pretended that the Supreme Court did the analysis in the Miller case, but the Supreme Court specifically said, we're not doing the analysis here because there's no evidence presented by the parties about the usefulness or the in common use or any of these things associated with this particular weapon, and we can't take judicial notice of it, so we're not deciding it for the purposes of this case. And yet, here this three-judge panel is pretending that that decision is somehow the law of the land, when all the court did in Miller was says there's just no evidence on this particular record. Now, the next major part of this decision, the bulk of it, was actually on whether or not silencers are even arms. And here, what the court said is basically they're not even arms under the text of the Second Amendment. Here's their rationale. The court wrote, quote, with respect to the second challenged regulation concerning silencers, Salim contends that silencers are considered arms that fall within the scope of the Second Amendment protection, or if not arms, reasonably necessary accoutrements. We disagree. The Supreme Court in Heller defined arms as anything that a man wears for his defense or takes into his hands or uses in wrath to cast at or strike another. Therefore, the Second Amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. While a silencer may be a firearm accessory, it is not a bearable arm that is capable of casting a bullet. Moreover, while silencers may serve a safety purpose to dampen sounds and protect the hearing of a firearm user or nearby bystanders, it fails to serve the core purpose of the arm's function. A firearm will still be useful and functional without a silencer attached, and a silencer is not a key item for the arm's upkeep and use like cleaning materials and bullets. Thus, a silencer does not fall within the scope of the Second Amendment's protection. All right, so this is all wrong on a whole lot of levels. To begin with, they're trying to argue, as you can see, this court is trying to say, that the only way an item can be part of an arm is if it's essential for the functioning of the arm. But that would mean that government could ban, let's say, safeties. It could ban trigger guards. It could ban sights. Because, we can fire firearms without sights, right? You don't have to be able to aim it. It will still function as a firearm. So at the first level, it doesn't even make any sense at that level, because there's a lot of things in an arm that are not essential to having the gun go bang. The second thing to keep in mind is it is no standard to say that something has to be an essential component of an arm to fall within the definition of arm in the text of the Second Amendment's right of the people to keep their arms. The key question is, does a particular object or instrument facilitate the use of the arm? Does it facilitate the use of an arm in self-defense? That's what Bruin says. Specifically, here's the language from the court case itself. Nyserpa versus Bruin, U.S. Supreme Court. Quote, even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition, listen carefully, that general definition covers modern instruments that facilitate armed self-defense. Hear what I just said? The Supreme Court in Bruin says that arms include modern instruments that facilitate armed self-defense, citing to Caetano dealing with stun guns. So that's critical language here, because first of all, it shows us it doesn't have to be essential, because a lot of things are helpful, which means facilitate, without being necessary, right? Again, sights to me is a basic example. A gun will go bang bang without sights, but to have sights or ability to aim the gun facilitates or helps the use of a gun. And I don't think you can ban sights. I don't even think Judge Wilkinson would agree with that. Beyond that, if the Supreme Court just was interested in protecting the essential components of a gun, they would have said that arms constitute and protect modern weapons. Hear what I just said? Modern weapons. But that's not what the Supreme Court said. It was much more nuanced and much more favorable to us than that. Rather than saying the Second Amendment arms definition encompasses modern weapons, it says that it encompasses instruments that facilitate armed self-defense, which is a broader concept to include more stuff than just modern weapons. But Harvey Wilkinson there on the Fourth Circuit is trying to narrow the scope of arms to just weapons themselves and their essential components. And the last reason why it's wrong to do what Judge Wilkinson did there is because, think about it for a moment. What is the one thing everyone agrees that Heller and Bruin said? No more interest balancing. No more balancing of good and bad. No more weighing of interest. No more, hey, I'm a black robe mystic sitting in Virginia at the age of 97. And I'm going to weigh out the benefits and the good and the bad of all this stuff because I'm an intellectual giant and you're a peon. No, that's not what the Supreme Court said. The Supreme Court said you can't do that. Why is that relevant to this discussion about silencers? Because if you think about it, what constitutes something that is an essential instrument or an essential core or component of a firearm is really interest balancing. You're asking, what is essential, in my opinion, as a black-robed mystic, as a judge? But that's no good. And that particularly applies in the context of suppressors, because let's step back and think about this from a common sense point of view. Millions of people have bought millions of suppressors and registered them through the NFA. And Congress defines suppressors and silencers as firearms under the statute. And the ATF treats suppressors and silencers as if they're components of firearms. So here you have Americans, millions of Americans are treating silencers as if they are impacting or affect the functionality of a firearm. Suppressors are regulated because they affect the functionality of a firearm. They're defined as firearms by Congress because they affect the functionality of a firearm. So both from the private citizen point of view, Congress's point of view, and the regulator's point of view, these suppressors affect and regulate and implicate the functionality of a firearm. So how can you say they're not related or concerning a firearm? How are they not an instrument that facilitates self-defense of firearms in modern-day America? You simply cannot do so. Beyond that, let's go to my most fundamental point that I keep trying to tell everyone to argue because it's the easiest way we win these cases dealing with gun ban cases, dealing with things like suppressors and magazines that hold more than 10 rounds, and that is this. Step back and think big picture, folks. You're the intellectual giants of the Second Amendment. I'm training you to be such. What do you do, in effect, if you ban suppressors? If you ban silencers? What have you done? You have banned an entire category of firearm. And what is that category? It is all firearms that fire suppressed rounds. Hear what I'm saying? If you ban suppressors or regulate suppressors, you are either banning or regulating an entire category of firearms. Firearms that are able to fire suppressed rounds with reduced noise levels. So banning a suppressor is effectively banning a category of firearms. Just like if you ban magazines that hold more than 10 rounds, you have banned an entire category of firearms. Not just the magazines, but firearms, because you ban an entire category of firearms that are capable of firing more than 10 rounds without having to be manually reloaded. These are firearms bans. When they talk about banning parts, always step back and realize what they're really talking about is a type of firearm ban. Never forget that. All right, folks, so there you have it. I'll put a link to this decision of United States versus Salim down below. Tell me if you disagree with what I have to say. Make sure you follow me on X at @4boxtime. We have over 20,000 followers over there. Make sure if you're going to vote for the gunnies, you can vote every single day through now in December, through December 17th. Make sure you vote for Mark Smith, 4 Boxes Diner, in the top voices, the 2A. A lot of good competition there, but I think this year we can break through. And make sure you subscribe to this channel. We're trying to get to 200,000 subscribers. We're pretty far behind everybody else, but I think we can catch up there as well. And I look forward to talking to you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.